Well, folks, this is document 264, filed on September 6, 2022, in the saga with Andrew Colborn versus Netflix. Declaration of Lita Walker. Lita Walker, under penalty of perjury, subject to 28 U.S.C. 1746, declare as follows. I am one of the attorneys for defendant Netflix Incorporated. In above caption action, I personally acknowledge of the matters set forth herein. I make the declaration in support of defendant's joint, unopposed civil L.R. expedited non-dispositive motion for leave to exceed page limit for brief. Exhibit 1 is a true correct copy of the produced defendant's course of discovery, Bates stamped, as seen on pages 4,724 through 4,725 of Exhibit 1. The Wisconsin Department of Justice Case Activity Report Special Agent Deborah K. Strauss states, the following is a list of documents which were being maintained in the safe in the office Sheriff Peterson, including one-page statement signed by Andrew L. Colborn. Attached here to Exhibit 2, a true and correct copy of expert from the deposition of plaintiff Andrew Colborn, lines 4 through 11 of transcript page 404, in which he admits that that his written statement was kept in the sheriff's department safe. Attachment here too, Exhibit 3 is a true and correct copy of the document produced by plaintiff's former counsel of record, Michael Griesbach, Bates stamp Griesbach 000454, on page 468 of Exhibit 3, encircled and highlighted, Mr. Griesbach hand wrote that Wisconsin Department of Justice report said nothing re Brown County Jail to Colborn and Sheriff's Office safe. Declare under penalty of perjury foregoing true and correct September 6th, 2022. And here goes Exhibit 2. Looked at earlier, which the statement you prepared on September 12th, which was the day after Stephen Avery was released from prison. Now, why did he wait so long? Yes. Question. Now, so would you agree that based on this document, at least that what this document purports to say is that your statement was, in fact, kept in the Sheriff's Department safe? Answer, yes. Question. And yesterday, you stipulated to the fact that, right? Yes. Okay, now you said that James Link had given some incorrect information to Sheriff Peterson. Answer, yes. How did you know that? The paragraph that reads, Sergeant Colborn said he was later informed by someone that the case was already solved and the right person was arrested. I never said that. And how do you know that was what he passed on to the Sheriff Peterson? I'm reading it off his statement, so I wasn't there when I don't know what he said verbally to the sheriff. That was going to be my question. Alright, and then we got the Exhibit 3, which is the Jeep, the four-wheeler in the pit. Well, smart. Check these facts on another witness to see if this is true. Insert it into the lamp looks back section. Use this. This shit's something media interview. Use. I can't read this chicken writing. Media interviews. Have it had together. The Attorney General some shit opinion. Correspondence Memorandum Department of Justice, December 17, 2003, 8/14/10. Have Hardy during press interviews. Explain 12/29/08. See the green. The Wisconsin Department of Justice evaluated facts, circumstances, 1985 investigation and prosecution. Stephen Avery was convicted of attempted first-degree murder, first-degree sexual assault, and false imprisonment on December 14th, 1985. In September 2003, 18 years after Avery commenced his prison term, DNA testing exonerated Avery and implicated another person, Gregory Allen, Department of Gold, was to assess what, if any, errors occurred during the investigation and prosecution of the Avery case, and whether any criminal or ethical violations were committed by anyone involved in handling the case. Call it the Department of Justice. I read all of this on my channel before, but I mean the actual this. District Attorney Mark Rohr, December 17, 2003. October 1995, Avery had 16 alibi witnesses to his whereabouts on the day of the assault. However, he was convicted of crimes and sentenced to a total of 32 years in prison. In September 2003, the results of the second round DNA testing on pubic hairs obtained after the 1985 assault were received. These tests revealed that Avery was not perpetrator of the crimes. Avery was released from prison on September 11, 2003. Gregory Allen, whose DNA matched the pubic hair, is serving a 60-year sentence in sexual assault he committed in Green Bay in 1995. On September 18, 2003, Curtin Manitowoc County District Attorney Mark Rohr requested that the Wisconsin Department of Justice conduct an independent review, and the department agreed. Two special agents, Division of Criminal Investigation Amy Lehman and Deb Strauss, conducted an investigation. The report is based on interviews from victim and sheriff department deputy sheriffs involved in the investigation, former Manitowoc County District Attorney Dennis Vogel, personnel who worked in Vogel's office, and time of the prosecution, officers of the Manitowoc and Two Rivers Police Department and defense counsel handling Avery's case in trial court. The department has also reviewed files from the sheriff's department, files of the prosecutor, defense attorneys handling the case, the transcripts from Avery's proceedings, including the trial, appellate court records, numerous police reports in the sheriff's department and Manitowoc Two Rivers Police Department. The report examines critical points of investigation and prosecution in Avery's case. The composite drawing. After Penny Bernstein was transported to the hospital, she participated in creating a composite sketch of her assailant with Chief Sheriff's Deputy Jean Couchet. The composite drawing was completed at 10:20 p.m., approximately 6 hours after the assault had occurred. At a suppression hearing, Deputy Couchet testified that before he did the drawing, a name was given to him as a suspect. However, he did not have any personal recollection. The individual had no mental image of him at the time of the drawing. Yeah, I don't believe that one bit. Seeing how you traced his fucking mugshot. As was told, they had mugshot of the suspect. However, he was told everyone not to show either him or the victim any photographs. Penny Bernstein testified at trial that she was never given any suggestions as to how the suspect should look. The department had not uncovered information challenging the integrity of the composite process. Yeah, but you guys failed to recognize that you only put Stephen Avery in both lineups. District Attorney Mark Rohr, December 17, 2003, page 3, photo array. Issues involved in the photo array were addressed in Avery's final appeal. While the photo array was not perfect and met applicable legal standards, it does not demonstrate any misconduct on the part of the Sheriff's Department. Sheriff Kasurk told investigators that he did not know Avery at the time, but that after Penny Bernstein gave a physical description of the assailant, someone said the description sounded like Avery. Oh, yeah, Judy Dvorak. Deputy Judy Dvorak had been called to the hospital to take a statement from Penny Bernstein. The Department review indicates that Dvorak, who made the comment and was description that sounded like Avery. It was because of his statement that Kirk asked that Avery photograph be included in the photo array. The photo array was conducted approximately 10:20 p.m. After completion of the composite drawing, the sheriff laid out 9 photographs at the table tray at the side of the Penny Bernstein hospital bed. Avery was somewhere in the middle of the array. After Penny Bernstein chose Avery after assailant, the sheriff told her he was going to apprehend the suspect. It is an unpublished decision of the Court of Appeals dated August 5, 1987. The court reviewed Avery's challenges in the identification procedure, namely the photo array and that the live lineup. Avery contended that the photo array was impersonally suggestive because the sheriff testified he put the array together and that told Penny Bernstein that there was a chance that the suspect might be in there and that she should look at them and attempt to determine if the fact it was. The court relied on Fell State, Wisconsin, yada yada yada, concluded the sheriff's statement, standing alone, did not render procedure admissibility suggestive. The statement did more than tell the victim what they already implied by conducting the photo array, that is, the attacker's picture might be included. The court also examined photographs from both the photo array and the live lineup. With regard to the array, the court stated the pictures in the photo array displayed individuals who correspond to the description given by Penny Bernstein, and who was closely resembled to another Avery does not stand out from them. In fact, the photo array consists of the fairest ones that the court has seen. The array did not include a picture of Gregory Allen. The live lineup, Avery challenged the test legitimacy of the lineup in the appeal discussion above. Suppression hearing revealed the following circumstances surrounding the lineup. Avery was the only person in both the photo array and the live lineup. Assistant Public Defender Stephanie Stolman was present during the lineup. The lineup was conducted 3 days after the assault. Stolman, the lineup was okay. And Stolman requested that some of the participants be moved in order to get a closer height and age coloration range. After they were positioned, Penny Bernstein was led into the room, which adjoined the room containing the lineup and had a one-way mirror for viewing the participants. At some point, someone requested that Penny Bernstein's husband not talk to her during her observation and that he step away from her. There were 8 males who participated. Stolman stated that Avery appeared to be the youngest, the fairest, and the shortest of the participants. A few of the people were fairly well dressed. One of the participants looked at Avery during most of the lineup. Penny Bernstein testified that no one suggested to her whom to pick out during either the photo array or the lineup. And suppression hearing, Penny Bernstein testified that there was nothing in any of the participants that did not live lineup that suggested to her that the person to pick out was Avery, or that drew attention to Avery. After she picked out Avery, she went to the sheriff's office, where she was told that the person she had picked in the lineup was the person that had in custody based on the photo identification. Kirk testified in suppression hearing that the choosing the people for the live lineup, he looked for people with full beards and mustaches and people close to the height to Avery, which is difficult because he was quite short. He believed 3 of the people in the live lineup were very close to Avery's height. He also believed that some of the Penny Bernstein was told that they had arrested a suspect and the suspect would be in the lineup. However, she was never told that the person she picked from the photo array would be in the lineup. The lineup contained one other individual who had history of type of crime, but was not Allen. On appeal, Avery alleged that the lineup was suggestive because he was the only person who was in both the photo array and the lineup, because he was the youngest, fairest, and shortest person in the lineup, the only one with straight hair. He also contended that some of the other participants were dressed up, and participants turned toward him during most of the lineup. The Court of Appeals concluded that the photographs of the lineup revealed that the group of participants reasonably resembled Avery in terms of age, hair color, complexion, size, manner of dress. In addition, like Avery, all the participants had beards and mustaches. District Attorney Mark Rohr, page 5. Based on the pictures of the lineup, the court concluded that the police secured a fair and balanced presentation and alternative possibilities of identification. Avery also argued that even if the identifications were admissible, Penny Bernstein's identification of him was not sufficient to negate the alibi offense. The court rejected the argument based on well-established Wisconsin law, indicating that the eyewitness testimony of a victim is sufficient to sustain a conviction, even absent corroborating evidence. The Court of Appeals further stated, moreover, in the case of Penny Bernstein's identification could be deemed by a jury to be particularly convincing based on testimony indicating that she had ample opportunity to view him. She was consciously determined to get a good look at him, and her initial description subsequently matched Avery's appearance, and only 6.5 hours passed between the assault and the initial identification. There is nothing to indicate that the live lineup was unduly suggested, otherwise improper, as was the photo array lineup did not include. This decision to arrest charged Avery while failing to consider Allen as a suspect. At the time of Penny Bernstein's assault, the Sheriff's Department was familiar with Avery from identification that occurred only 6 months earlier in January 1985, in which Avery ran a deputy sheriff's wife off the road at gunpoint and told her to get in his car. The woman told him that she had her baby in the car. vehicle and the baby would freeze. After checking to see if the child was in fact in the car, Avery let the woman go. He confessed to the crime and stated that he had done this because the woman had been making allegations that he appeared naked in front of his yard on several occasions. Well, that sounded like a car accident. I don't know if y'all heard that. January, where was I? Current statement assaulted against Penny Bernstein. District Attorney Vogel told investigators that he assumed that the January incident involving Avery was sexually motivated. After was also convicted in Manitowoc County in 1981 of 2 counts of burglary, which he received 5 years of probation, and was convicted in 1982 of cruelty to animals. These cases were handled by Vogel, but by assistant prosecution in the office. We got some little footnotes. Whitewash. The sheriff's department's suspicions regarding Avery were bolstered following Penny Bernstein's positive identification of Avery as her assailant in both the photo array and her live lineup. Suspicions were further validated by statement of his wife upon arrest. He was being accused of murdering a girl, although no one had identified him a victim as a female, and the fact that the Avery alibi was that he had been pouring out cement all day and his clothes tested negative for the presence of cement dust. Yeah, okay. Lampe, you got to be kidding me. Facts that determined Avery an assailant, which the jury heard, included 16 alibi witnesses. The fact that Shopco employee and receipts confirmed that at the Shopco in Green Bay at 5:13, only an hour and 15 minutes after the assault near Two Rivers in Green Bay. Shopco, able to through checkout line 57 minutes and after leaving the crime scene, but the officers admitted that they went 10 miles per hour over the speed limit to reach those numbers, and offer service did not account for potential delays resulting from the presence of 5 children, including 6-day-old twins. All of them were seen with Avery and his wife at Shopco. Moreover, the reenactment did not allow any time for picking up Avery's family. It would therefore assume that Avery's wife and 5 children were at the beach somewhere or in the car while he committed the assault. Whitewash. Lame. Cut this. Excuse me. Sorry. This chicken scratch is hard to read. That all by show that wash was possible. I guess there's a little footnotes trying to bolster why it could have gone through. 1985, another footnote. Green Bay. Moreover, reports from Manitowoc County Sheriff's Department indicated that on November 15th, 1983, Sheriff's Department had information that Allen would expose himself and masturbate in front of children. Allen was also chief suspect in murder of a 15-year-old girl in North Carolina on June 16, 1975. Detective Conrad of the Manitowoc County Sheriff's Department had the information and gave it to Detective Thomas Bergner of the Manitowoc Police Department. Bergner is now the Manitowoc Deputy Police Chief. Manitowoc Deputy Police Chief Thomas Bergner told investigators that he was working for Manitowoc Police Department in 1985, that all jurisdictions were very territorial at that time and did not like to share information or contact other agencies regarding investigations that we're working on. Despite the relationship, shortly after the investigation began, Bergner went to Kirk and discussed the incident of assault of Penny Bernstein. Bergner asked if Kirk knew about Allen. Kirk told Bergner that Allen had been ruled out as a suspect. Bergner got the impression that Kirk knew about Allen and Allen's history. Kirk told investigators that he did not recall such an incident. He further said that in 1985 he was not aware of Allen and did not think anyone else in the sheriff's department was. Bergner believed that Allen should be considered a suspect because he was a suspect in other sexual assaults around the same time Allen was a suspect of attempted sexual assault on July 14, 1995, Manitowoc, 2 weeks prior to the assault on Penny Bernstein. Allen was never charged in the matter because there was insufficient evidence. Penny Bernstein told investigators that within weeks of the assault, they received a telephone call from someone in the Manitowoc Police Department. The individual told her that they had someone in the mind that matched the description of their assailant, and the subject was not Avery. Police asked Penny Bernstein if she ever noticed anyone watching her while she was at home, watching her at the YMCA where she worked, and simply following her around. Penny Bernstein had in fact received harassing phone calls following her assault, even after Avery was arrested. Many of the phone calls were of sexual nature, some of which were occurred 5 minutes after she would return from home, indicating that she might be watched. Some post-crime contact and stalking behavior was consistent with Allen's post-offense history. See below. Penny Bernstein contacted the Sheriff's Department and believes that she spoke directly to Sheriff Kasurk. Penny Bernstein also asked if there was another suspect and related contents of the phone call from Manitowoc Police Department. She was told the Sheriff's Department would contact the police department and she should not worry about the phone call because the Sheriff's Department had jurisdiction over this case. Kasurk told investigators he did not recall such a conversation with Penny Bernstein. Page 8. Had the Sheriff's Department reviewed the police reports of the Manitowoc Police Department, following information would have been discovered, making Allen a prime suspect in the assault of Penny Bernstein. Allen had been convicted of aggravated offenses as juvenile. The Manitowoc Police Department file contained a police report from the Two Rivers Police Department regarding a crime Allen committed in 1983. According to the police report from the Two Rivers Department on August 2nd, 1983, Allen came up over some sand dunes on the same beach on which Penny Bernstein was assaulted, only some distance south of the point, and began walking behind a woman. He then pulled his shorts halfway down and began masturbating. He then lunged at her, and the woman was able to run away. Following the incident, Allen contacted the victim twice at her home and asked her to drop charges. The victim moved to Green Bay for school and did not know how Allen knew this or how he knew her phone number. Allen also contacted the victim's mother 5 days after offense and asked to talk to Sue, which was the victim's name. Allen had been convicted on February 20th, 1994 for disorderly conduct with the cities of Two Rivers. On June 13th, 1994, Allen was the suspect in a prowler case in which he attempted to gain entry to a woman's residence in Manitowoc after following a 16-year-old daughter, her daughter's friend. Allen was suspected of prowling on January 24, 1985, and February 2nd, 1985, Manitowoc, involving walking into people's yards up to their garages and homes. Directory Central till end. DA, see my next page. January 1985, Allen was suspect following investigations. A woman told Manitowoc police at 6:30 a.m. she saw a male subject wearing a ski mask between her yard and neighborhood yards. Other note. Something about Kelly informants start here. On July 14th, 1985, 2 weeks prior to Penny Bernstein's assault, the suspect breaking into the man's home at 3:20 a.m. attempting to assault his daughter. Yada yada yada. More notes. This chicken scratch sucks. Something blue of Bergner was what Sally told that was some ass. For your info, it's Dan Bells. Additional personal. Yeah, I've read all this before on my channel. It's nice to see these chicken scratch notes, complete whitewash. Viewing of the foregoing, Allen would have been more logical suspect for Avery. Allen agencies their information. However, because the Sheriff's Department had only one suspect in mind, time and photo array, Penny Bernstein identified the suspect as assailant, and the sheriff and eventually district attorney became convinced that Avery had no one else responsible for the party. Compliance discovery requests. Something on the show beach. SAC Glenda. I can't read none of this. Whitewash. Like what? Yeah, this shit's hard to read. Scrap must use short gun like these. Completely, utterly begs the question. No shit. Report said nothing on Brian C. Joint called Colborn. Following embarrassment from Avery and established the scientific analysis available to determine I can't read none of this shit. More outrage, as if that would wild to Monica Dre, New York Times, from Mike Griesbach, Avery case, Wisconsin Attorney General, Peg alongside a report on her. So these are Michael Griesbach's notes that are written on all these paper. Hi Maria, you daily president from Wisconsin. I thought you were, but want to take a look at this. This is justice in the suppressed work. Sorry for the scribble notes on the report. To D Hall, Wisconsin Journal, Avery State AG report. Sorry for the scribble notes. ID. Here's the AG report on the Avery News reaction. Sir Vogel also had bad. Are the pictures? If so, can I send where I looked so goofy? To HIR attorney Patent Charlie Matthews from Michael Griesbach. Read Avery book. Here's the AG report I referred to in my email. Alright, and then we got yep, I believe that's it. Wait, no. Yep, that would be it. Well, that's the latest installment in this saga for Andrew Colborn. Hopefully I get my PC fixed, and I'll see y'all next time.